we'll go here. This will do view latest bill text. So it passed the assembly. So this bill requires manufacturer of firearms in the state of Wisconsin to include a stamp on the firearm that reads "Made in Wisconsin" or a similar stamp. This requirement applies only to firearms manufactured after the effective date of the bill. At first text reading that, I was like, well, that's shit. Why would I want to do that? And then I read on, and under this bill, a firearm, accessory, or ammunition that is owned or manufactured in this state and that does not leave this state is not subject to federal regulation under the Interstate Commerce Clause of the U.S. Constitution. Also under this bill, if a person incorporates a firearm component from another state into a firearm manufactured in Wisconsin, the incorporation does not subject the firearm to federal regulation under the Commerce Clause. In the case of the challenge to this provision, the legislature has included an intent statement that finds authority for it in the 2nd, 9th, and 10th Amendment of the U.S. Constitution and in Article 1, Section 25 of the Wisconsin Constitution. The bill also prohibits from enforcement of federal act, law, statute, rule, regulation, treaty, or order that takes effect after January 1st, 2021, if it bans or restricts any semi-automatic firearm, assault weapon, or magazine, requires registration of firearms, magazines, or other firearm accessories, regulates the capacity of magazines, regulates the quantity of ammunition or bullets an individual may possess, prohibits types of ammunition or bullets, or requires the confiscation of a firearm. The bill creates some exceptions, including allowing for the enforcement of such a federal law if it is identical to a state law. A person who violates the prohibition is guilty of a Class A misdemeanor. Finally, the bill prohibits any state agency or other body in state government and any local governmental unit from expending monies or using other resources to confiscate a firearm, firearms accessory, or ammunition that is lawfully possessed under the laws of Wisconsin. Because the bill creates a new crime or revises a penalty for an existing crime, the Joint Revenue Committee on Criminal Penalties may be requested to prepare a report. General consensus is this would be fantastic if fucking Texas would pass it. It's not going anywhere in the state of Wisconsin. Interestingly, there's a statement here. I kind of wanted to read this now because I found this. So it states that the proposals are meaningless and unconstitutional. The state legislatures are not in a position to interpret the constitutionality of any law under the separation of powers doctrine, including federal laws. Despite the legal analysis written into the bill, the Wisconsin state legislature has no ability to determine the constitutionality of the federal law. This is actually correct. That's a true statement. However, intent statements that outline the authority of them to have it are just precursors to what they know is going to be a court battle. And it's just an opportunity for them to say, hey, before we even start, we're going to be citing these constitutional amendments. Prepare your citations in accordingly. So the U.S. Constitution grants the federal judicial branch the unique authority to interpret the constitutionality of laws passed by the federal legislative branch. This is true. And of actions passed by the federal executive branch when states turn to nullification as a remedy for perceived unconstitutional infringements in the context of school integration. The Supreme Court clarified that it is not the states, but rather the court that is supreme in the exposition of the law of the Constitution. Thus, this Second Amendment sanctuary bill, which attempts to nullify federal gun law via the Commerce Clause, would itself be null and void. Last statement is not true. Two different apples and oranges type deal. There is grounds and standing for it. So then saying state level sanctuary laws violate the Supremacy Clause. The Supremacy Clause provides that the federal Constitution and federal laws are the supreme law of the land. It also establishes the principle of preemption, meaning that if there is a conflict between laws, the supreme law takes precedence. As a result, if a state law conflicts with federal laws, it is invalid because state cannot interfere with the federal government's exercise of its constitutional powers. Thus, if a state sanctuary law conflicts with the federal law, it is invalid by preemption. As the federal 10th Circuit put it, when different governments differ in their assessment of danger, one must prevail. And the Supremacy Clause says that in these circumstances, it must be the United States. Well, two things. Number one, sanctuary cities sound familiar? So what about the cities saying that we're not going to enforce federal law on immigration policy So we can allow sanctuary for illegal immigrants in this United States to bypass federal law and live free and clear in their cities. So either you've created a hell of an argument against your own policies, or you're right. And, well, this is true. And number two, the federal government only sustains as much power as the local government, people, and officials will grant it in a local area. So, jurisdictionally speaking, the federal government is only capable of enforcing laws on a federal level on federal property. So, even though there is federal property in the state, that technically is the only place that the federal government has any authority. Anything else is granted to them by local jurisdictional prudence. So the local police departments, the local law enforcement have to ask the Federal Bureau of Investigation or the ATF for somebody to come in and perform their tasks. Or the ATF and the FBI, all of them, have to ask the local police if they can come do that. This is not simply a courtesy. This is not simply a courtesy. This is actually law, right? So they're giving them jurisdiction. They're offering them an extended olive branch of power for them to come do what they need to do, or to bring them in to help them with the resources. So if the local government refuses to enforce a federal law, guess what? It's not a federal law that's being broken. It is a local ordinance or local violation that they're ignoring. So, right there. The other portion of that, I'll even go number 3, marijuana. If talking about supremacy clause and all that stuff is how you're going to defend this, then how is it that state governments are able to legalize marijuana, which is federally outlawed? It's a crime federally to own, possess, use marijuana. Yet, how many states currently have legislation, bills, laws saying that marijuana is legal in their state? They refuse to enforce federal law on it. Right? So now what I'm talking about jurisdictional prudence prevails, because even in the states where it is legal for you to smoke marijuana, so say Illinois, so you go to Illinois or Colorado. Colorado's had it for a while. It's there. Everybody knows about it. Go to Colorado, and you've got a joint in your hand. And you happen to walk on the sidewalk in front of the federal office building for the FBI. I know there's one in Denver. Okay, so you walk on the sidewalk directly in front of the Federal Bureau of Investigation in Denver, Colorado. Based on eminent domain law and property rights, technically the federal government owns the property the building is on. They own the sidewalk in front of the building, and they own to the center of the road in front of that building. So even if you leave the sidewalk and walk in the road, which would in itself be a violation of laws, you turn around and now you're breaking a city law, a local one, on top of a federal law. If an agent of the FBI comes out of that building and sees you in possession of marijuana, he can physically arrest you, put you in detention, and charge you federally for possession of a controlled substance, even though you're in a state where it's legal, because of the supremacy clause. However, he can only do that because he has jurisdictional prudence in that area. So if you are at a national park in a state where it's legal to smoke pot, and you smoke pot in that national park, you can and most likely will be arrested, detained, and charged federally for a drug violation, even though it's legal in that state. So that is the supremacy clause. Yes, even though it happened in the state of Colorado, You are arrested by federal authorities on federal property, which is federal jurisdiction, which means you were subject to federal law. If you were on the opposite side of the road of the Federal Bureau of Investigation in Denver, Colorado, and smoking that joint, you would not have been arrested. Not only would you not have been arrested, you probably wouldn't have been pursued. They probably wouldn't have even batted an eyelash at you. Now, in these states, is that happening? Maybe not, but it could. It legitimately could. This is why states even that have laws where it's legal to smoke pot, it's a really bad idea to do it if you want to be a gun owner. Because technically, if you fill out a 4473, you have to be honest with all the answers on that 4473, or you are in violation of, lying on a legal document to the Federal Bureau of Investigation, to a federal authority. So technically, you are perjuring yourself on a federal form. Not a good idea. Not a good thing to do. By saying, no, I'm not breaking federal laws, or I'm not in violation of any federal laws. Because if you smoke pot and you fill out a 4473 and you say no to that question, you lied. If you say yes, you're not going to get a gun because you're violating federal law, right? It's just all a fucking shit show. And then they go on to cite some Montana laws. And in fact, a Montana law very similar to this bill has already been found to be invalid by federal courts after the passage of the Montana Firearms Freedom Act, which provides that any weapon manufactured and remaining in Montana cannot be regulated by Congress. Several plaintiffs filed suit seeking judgment on its validity. They specifically argued that the MFA allowed Montanans to legally manufacture and market entirely in Montana a .22 caliber rifle without complying with federal licensing laws. However, the district court dismissed the suit. The Ninth Circuit Court of Appeals affirmed, finding that the plaintiffs failed to state a claim because the MFFA was preempted by federal licensing law and, as such, was invalid. Technically, you could say you weren't smoking at the time. This is true, AWG. Welcome to Mario. Better late than never. Have a drink. Fuck you. Big kisses. All good. We're doing all right. Technically, you could say that you weren't smoking at the time of filling out the application, yes. However, if you possess it, right? If you possess it, if you have it at home or whatever, technically, whatever, it is not a crime to be high. You can be high and fill out that form, technically. It is not a federal crime to be high. It is a crime to get high. So let's be honest about that. So, claim, because the MFFA was preempted by federal licensing law, as such, it was invalid. Passing AB293 would certainly bring a similar lawsuit and resulting invalidation in federal court, requiring Wisconsin taxpayers to foot the bill for unconstitutional political grandstanding. Yes, no, maybe so. That's kind of the whole thing there. So, I'm not familiar with the MFFA. Depending on the wording, depending on the way it was put together, it could have been a problem. Most likely, whatever. Like I said, this doesn't matter because it's not going to go anywhere anyways, but it is there. The goal of this bill is the creation of a refuge where federal gun laws will not be enforced at all. According to the author's press release, the goal is preventing the federal government from infringing on the rights of legal gun owners across Wisconsin. The most grave and obvious consequences of not following or enforcing federal gun laws is the loss of human life. Really? But this bill also poses the following risks: creating uncertainty and or emboldening that can result in tragedy. Even if the sanctuary law is not binding and enforceable, not all residents will know or understand this. At the very least, a formal sanctuary law will create confusion for law enforcement and private citizens who may incorrectly believe that they are not bound by federal law. At the very worst, the bill may embolden certain law enforcement officials and or private citizens to ignore or knowingly violate life-saving federal laws. I'd like to see where these laws are life-saving, number one. We ain't got the fucking mob running around here anymore. So I'd like to see where any of these laws are life-saving anymore. Yeah, interesting topic, right? We're reading a dissent bill on Assembly Bill 293 for Wisconsin right now. A dissent statement, essentially. So, at the very least, a formal sanctuary law will create confusion for law enforcement and private citizens. I don't disagree with that. Creating confusion is a problem, especially with a legal system set up the way it is. Ignorance is not a defense unless you're Hillary fucking Clinton. So, flat out, I'm 100% on that. It will create confusion, which could potentially put a lot of people in jail that don't belong in jail. It could potentially let a lot of people out that should be in. Sorry, dry throat. I must drink more booze. At the very worst, this may embolden certain law enforcement officials and/or private citizens to ignore or knowingly violate life-saving federal laws. I argue that they're not life-saving. The federal laws that are on the books, they're pandering. They're meant to make it so that the United States population does not have the same firepower that the federal government has, regardless of what anybody says. The main reason for abolishing the ability for the United States population to from having fully automatic firearms was essentially because law enforcement officers were going into streets against mobsters and shit like that who all had enough money to be running around with Browning automatic rifles and fully automatic Thompson submachine guns. Our officers were going into battle with fucking 9mm pistols and, if they were lucky, maybe a rifle. They didn't have the same money. This is the exact reason why the NFA cost $200. So a Thompson submachine gun at the time cost $200, which was extremely cost prohibitive. So the only people who could afford to legally purchase a Thompson submachine gun were the mobsters, the criminals. So one way to kind of go about, affecting that and preventing individuals from buying it was to add another $200 tax to it. So you doubled the price of the fucking weapon, which makes it even more cost prohibitive. And all they did was ensure the only people who had them were the criminals. So right from the beginning, all the people who had the illegal firearms were the criminals. So these laws that are supposedly life-saving only affect the law-abiding citizen. They don't affect the criminals anyways. So I argue they're not life-saving at all. I argue they're 100% bullshit. As evidenced by Lori Lightfoot's Chicago. Look at 7 Mile in Detroit. Motherfuckers, they got probably third, fourth most restrictive gun, laws in Detroit. I don't challenge anybody to walk down 7 Mile after dark. Because ain't nobody walking down 7 Mile after dark in Detroit. I don't care, gentrification or not. 7 Mile Bloods, not taking that chance, folks. Not taking that chance. Not with my weapons, not with your weapons, not with the fucking federal government's weapons. The police are not dumb enough to patrol that street at night. So, yeah. All right. So moving on. Number 2, creating criminal liability for confused residents. As mentioned above, there has been confusion among residents as to whether federal laws are still in effect for residents of sanctuaries nationwide. Some residents have unwittingly committed crimes, and some, emboldened by the sanctuary, have even purposely violated gun safety laws. However, even if Wisconsin did not enforce federal laws, they will continue to be enforced by federal agents in our state who can and will prosecute violations in federal court. True. This goes back to the fucking purview, though. They only have authority on federal property. So if you enter a military establishment, if you enter a federal building, a federal office building, a federal anything, you are under federal jurisdiction. Sanctuary laws do not apply. This is the same for immigration. This is the same for marijuana. This is the same for any state law that nullifies a federal law, because state laws can and do nullify federal law all the time, regardless of supremacy clause. However, the only time that the two governments conflict, which is the big misnomer there, is when the state property and the federal property are together, when that jurisdiction overlaps. So, yes, the Denver Bureau of FBI Division Office, right? The Denver Division Office of the FBI is in Denver, Colorado. In Denver, Colorado, probably a block away from there, you can buy pot. You can buy marijuana, whatever you want to call it. But if you walk by that federal building and you get stopped by a federal authority and searched and detained, you can go to jail for being in possession of something you legally purchased a block away, because you are on federal property. Federal property can exist inside state property. This is the same thing as United States property in other countries. The U.S. is granted property to put up their embassies. That's the word. They're granted property to put up the embassy. Now, our embassy in Colombia is United States property. United States laws need to be followed on that property, even though you're in Colombia. You can't walk into that fucking place snorting coke all goddamn night and expect to just walk back out the next day. I was protected for the night because I was in the embassy. Yeah, abortion clinics are pretty much the same way. Totally other topic. Yes, but yes. And then number 3 on this is creating civil liability for the locality and taxpayer. If a sanctuary bill results in the non-enforcement of gun laws, residents that have been injured by the non-enforcement could bring pricey lawsuits against the locality. In New Mexico, Attorney General Hector Balderas letter to New Mexico law enforcement, he warned the taxpayers of your city or county assume the financial risk of your decision to impose your personal views over the law. Sanctuary bills can create confusion for law enforcement officers who may believe they are not permitted to enforce gun laws, or embolden certain officers to ignore or knowingly not enforce gun safety laws. There's a difference here between gun laws and gun safety laws. Two completely different things. I oppose both. You should not be able to impose safety laws on anybody either. Let them do what they're going to do, so long as you are not harming yourself or others. Who gives a shit? If you harm yourself, I don't care if you harm yourself, as long as you're not harming others. Completely honest. There are dumbasses on Facebook right now. I could pull up a group and go, hey, look at right here. Look at this guy. He legitimately said that negligent discharges are a part of owning firearms, and if you have not had one, you've not trained enough with it. What? You're a fucking moron. Negligent discharges are not part of owning a fucking firearm. Negligent discharges are part of being an idiot. Keep your booger hook off the bang switch and you won't have a negligent discharge. Plain and simple. So training with your firearm would prevent that if you trained the right way. So like I said, I'm opposed to both, but whatever. When injury or death occurs from the failure to enforce, yeah, what the fuck? I know. Wisconsin has enacted a law that requires individuals subject to domestic violence restraining orders to relinquish their firearms to law enforcement. Yeah, that's normal. Individuals subject to domestic violence restraining orders to relinquish their firearms to law enforcement if an officer refuses to enforce this law and allows the abuser to keep a firearm stamped made in Wisconsin, and the firearm is used to injure. This is an invalid statement. So, number one, I do not actually believe Wisconsin has that law in place. I believe this is a mislabeling of the argument. I've heard this argument before. I kind of touched on it in the other video. Wisconsin does not technically have a law in place where somebody who's convicted of domestic violence or accused of domestic violence has to relinquish their firearms. We rely on the federal law to do that. Simple solution. Pass a state law that says that they have to do that. Now you're not prosecuting anybody or doing anything in federal law. You're doing it in state law. and it's 100% within purview. If there are federal laws that you would like, you can argue to put them in place. But let's locally vote on them and actually allow the people to decide the laws that that they're forced to abide to. Right? This is called the mutual contract of a republic. Let's not forget we are a republic. There are too many people who continue to argue the democracy portion of this, and I don't live in a democracy. I don't know about any of you currently watching. I'm pretty sure you all believe the same as I do. We live in a republic. There's a major difference between a republic and a democracy. Both governments have elected officials. However, in a democracy, your rights can be voted away from you without your say. In a republic, they cannot. Your rights are your rights. And we've allowed our shit to become a democracy in representation. And we need to change that and get ourselves back to the republic that we belong. This is why Thomas Jefferson said, when he was asked, what did you give us, a democracy or a republic? The response was a republic if you can keep it. We have failed to keep it for the most part. We basically have a republic in name only, but we can return to a full republic if we're smart about it. And bills like this could help that. So I'll move down to number 4. Forcing law enforcement officers to choose between enforcing gun laws or violating their oath of office. Local law enforcement officers take an oath to uphold the state constitution and its laws, and many state law enforcement officers' oaths include upholding the U.S. Constitution. All officers are obligated to protect and serve the public sanctuaries. Sanctuaries, especially those that threaten to penalize officers who enforce public safety laws, create impossible situations for affected officers who must choose between not enforcing life-saving laws and violating the very oaths they swore to uphold. Let's see. The Second Amendment. How does that read again? The militia being necessary to the security of a free state, semicolon. The right of the people to keep and bear arms shall not be infringed. Seems like they wouldn't be in violation of their oath of office. Seems like that is already happening. And number 4 actually gets scratched off the list if something like this passes. So, number 5, threatening economic development. Sanctuary status can negatively impact the jurisdiction's economy, as we witnessed in North Carolina in the wake of anti-transgender laws, and in Georgia as a result of new restrictive voting laws. So, okay, so what they're saying is people might not want to do business with us. Well, yeah, people might not, but a lot more people will, promise you. There's a very interesting phenomena that happens when all those things happen. So the interesting portion of this is that conservatives are generally the people who spend their fucking money in the first place. Liberals, Democrats typically are the individuals who don't have any fucking money to spend unless we give it to them. So this was put forward by Milwaukee program manager Brady. All right. Annalise Dickman, however you say it. Annalise Dickman from Brady United Against Gun Violence. If you haven't heard, Brady is one of the major proponents of our buddy David Chipman. David, I like to cook children, Chipman. They support him very heavily. So interesting. Very interesting. Wisconsinites value public safety, reliable enforcement of the laws on the books, and putting our tax revenues to the highest use, not risking them on unconstitutional bills that do nothing more than create divisiveness. Please stand up for your constituents by rejecting the dangerous waste of money, time, and possibility that life, and possibly life, that is AB 293. I don't know where y'all stand on this, but I personally think AB 293 would be great. I think it would. I know it's never going to pass. I think this is all just gerrymandering. It's grandstanding. It doesn't mean a goddamn thing. But that's the dissent. It's not very intelligent. It is what it is.